Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Time will tell. Time will tell.
This is a great week because we got so many different and a variety of cases here. So this next one, have you done this one? You want to take a shot at explaining the Minnesota two-hatter rule? Or?
I thought this was a very interesting case.
Yeah, me too.
And I had to read the statute very carefully to understand what was going on here. There's a situation where you have a firefighter working in a full-time department. Was it White Bear Lake fire as a firefighter, and then as a call firefighter or a paid volunteer in Hugo fire. This is in Minnesota. Apparently they're neighboring or very close by geographically. And this firefighter was answering the page for a fire in the Hugo fire district where she's part-time or fire department. And her career department responds in mutual aid. Mm-hmm. Acting on the instructions of a chief from her full-time department, she goes into the basement with, I believe, a captain from that department, find themselves waist deep in water and decide to get out, and in so doing, injures her knee. She ends up putting in for a disability retirement, which she originally gets as a non-line duty, and then that is subsequently changed to a line of duty disability with, I would presume, full pension benefits, but not from the Hugo Fire Department where she was part-time, but her retirement came out of her full-time job that she was not working for at the time she was injured. So it's a very interesting, very convoluted set of facts, but the way that their legislation is written, where it talks about to qualify for duty disability benefits, a firefighter must, for not less than 12 months before is the direct result of an injury incurred during or disease arising out of the performance of inherently dangerous duties that are specific to the positions covered by the Public Employees Police and Fire Retirement Plan. And nowhere in there does it say you have to be working for that department. Mm-hmm. So that department, was a White Bear Lake fire, they screamed foul. And on appeal, the court found for the decision made by the administrative law judge, which said that, no, the way the statute was written, which we do find to be ambiguous, is not going to be corrected by the court. That's going to have to be corrected by the legislature, and her pension benefits stand. And I had to go back and read it very carefully. Very interesting.
Very precise. There's a couple of questions I have. The way they decided it, to me, it makes sense because she was under the command of her career chief and career officer. And I wonder if she had been totally under the command of her part-time department, whether or not it would have come out the same way. But they never really get into that part of it.
I think it would come out the same.
Yeah.
And the magic phrase is here, inherently dangerous duties specific to the positions covered by the Public Employees Police and Fire Retirement Plan. It doesn't say you have to be working for mom or pop, just so long as you're doing a job. And the key here is who's paying your insurance. Yeah. And her full-time job was paying her benefits, not Hugo. And that's how they ended up getting stuck with it. And they raise an interesting and a very valid point too, because how many people are doing this? Now, this is not common here in New York, or at least in my area of New York. Mm-hmm. Of course, as the fire service changes now with, less volunteers coming in and going to more paid people, part-time paid people, blah, blah, it's going to have a ripple effect. But her paid department, her full-time department, does raise a very legitimate concern that they could end up paying pension benefits for people that aren't hurt working for them.
right.
That's a
Well,
legitimate concern.
would your opinion change if White Lakes had not even responded to this? If this was just strictly a you-go?
No, it would not. My understanding of how the statute is written
Yeah.
is she's still good, even if White Bear Lake hadn't been there.
Yeah. And this is interesting because it goes beyond just an injury at a fire. It can get into cancer, other presumptive injuries, heart, lung, and has the potential to go beyond that. So
There's a lot of moving parts.
that's for sure.
But I was very surprised when I saw the title of the article. I was like, wait, what?
Yeah. Well, some people don't like the idea of two hatters. It's funny. It's funny. Some of these same people go out and work, and they're union, and they'll go out and swing a hammer as a carpenter, and they're a non-union carpenter.
Don't cloud the issue with the facts. What are you doing?
You have a union, and they have non-union bartenders at their union hall. Right? Go figure.
You
right?
can't make this stuff up.
Yeah, don't point the finger of hypocrisy at me. But I don't know.
It raises a very legitimate policy issue. It really does.
Yeah. So I don't know. I kind of feel like if somebody is full-time in one department, part-time in another department, that's fine. If they get hurt, both departments ought to contribute toward the person's pension or whatever benefits they're going to get.
Right.
On a pro rata basis. You put in 40 hours in one and 20 hours in another. That's how we're going to divide it up.
But we're stuck with what the statute says, and that's
right. No,
the way it's written.
Yeah.
So if you don't like it, call your congressman.
All right.